In the world of criminal justice, few topics spark as much debate as plea bargains. They are the hidden force behind most convictions, shaping the fate of defendants before a case ever reaches trial. But while they speed up the legal process, critics argue they undermine the very principles of justice. Are plea bargains an essential tool for an overwhelmed system, or do they create an uneven playing field where power, pressure, and fear decide the outcome? Plea bargains work by offering a deal. The defendant agrees to plead guilty in exchange for a lighter sentence or reduced charges. This avoids the uncertainty of a trial, which can result in harsher penalties if the defendant is found guilty. Prosecutors use plea bargains to secure convictions quickly, while defendants often accept them to minimize risk. But the process isn't as simple as it seems. One of the strongest arguments in favor of plea bargains is efficiency. Courts are overloaded with cases, and without plea agreements, the system would grind to a halt. A full trial can take months or even years, while a plea deal can resolve a case in days or weeks. Prosecutors see plea bargains as a way to secure a conviction without the unpredictability of a jury trial, and judges appreciate the ability to move cases through the system quickly. Defendants, particularly those facing overwhelming evidence, may benefit from reduced charges and a shorter sentence. But critics argue that plea bargaining has serious flaws. One major concern is coercion. Defendants, especially those with limited financial resources, may feel pressured into accepting a deal even if they are innocent. Public defenders often have overwhelming caseloads and may encourage plea deals to avoid lengthy trials. In some cases, prosecutors threaten severe penalties at trial to push defendants into accepting a deal, even when the evidence against them is weak. This creates a system where the outcome of a case may depend more on negotiation skills than actual guilt or innocence. A striking example is the case of the Central Park Five. These young men were pressured into accepting plea deals under intense police interrogation. Years later, DNA evidence proved their innocence, highlighting how plea bargains can sometimes lead to wrongful convictions. Cases like this raise concerns about whether the plea bargaining system prioritizes speed and efficiency over truth and fairness. Another issue is sentencing disparities. Two defendants who commit the same crime may receive vastly different sentences depending on whether they take a plea deal or go to trial. Those who exercise their right to a trial often face what's known as the trial penalty, harsher sentences imposed to deter others from rejecting plea deals. This has led to concerns that the justice system prioritizes efficiency over fairness, effectively punishing defendants for insisting on their right to a fair trial. One of the most controversial aspects of plea bargains is their role in wrongful convictions. Studies have shown that innocent defendants sometimes plead guilty to avoid the risk of a long prison sentence. This is particularly true in cases where mandatory minimum sentences apply. A defendant facing decades in prison may choose to accept a plea bargain for a lesser sentence rather than gamble on a trial where the stakes are much higher. This raises ethical concerns about whether plea bargains prioritize convenience over truth. Supporters of plea bargaining argue that without it, the system would be unmanageable. They point to the benefits for victims, who are spared the emotional toll of a long trial, and for defendants who receive a measure of certainty. However, opponents argue that any system that pressures people to plead guilty, especially when they might be innocent, compromises the integrity of the justice process. Despite the controversy, plea bargains remain the backbone of the American legal system. Over 90% of federal cases and the majority of state cases are resolved through plea deals. The question remains, is this an efficient necessity, or does it tilt the scales of justice too far in favor of prosecutors? If justice is about finding the truth, should deals be a part of the equation? Or do plea bargains force justice into a negotiation table rather than a courtroom? What do you think? Share your thoughts in the comments. Like and subscribe to Zero Hour Files for more deep dives into legal controversies and the justice system. As Mats Fredriksson wisely says, justice should not be a negotiation, it should be the pursuit of truth.